Hello, and welcome to the Motion for Summary Judgment and Motion for Summary Adjudication module. Before we begin, please be advised that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney. Let's first go over what these two motions are. A motion for summary judgment is a court order ruling that no factual issues remain to be tried, and therefore a cause of action or all causes of action in a complaint can be decided upon certain facts without trial. A summary judgment is based upon a motion by one of the parties that contends that all necessary factual issues are settled or are so one-sided they need not be tried. The motion is supported by declarations under oath, excerpts from depositions which are under oath, admissions of fact, and other discovery, as well as legal argument that argues that there are no triable issues of fact and that the settled facts require summary judgment for the moving party. A motion for summary adjudication is a court order ruling that certain factual issues are already determined prior to trial. This summary adjudication is based upon a motion by one of the parties contending that these issues are settled and need not be tried. The motion is supported by declarations under oath, excerpts from depositions which are under oath, admissions of facts by the opposing party, as well as legal arguments. Where you'll find the opportunity to use a motion for summary judgment or a motion for summary adjudication is during the discovery process. You may find yourself with enough material, facts, and support to resolve the case in your favor before it ever goes to trial. The purpose of these motions is to halt your case before you have to go to trial and bring material facts to the judge to review in hopes that the case or portions of the case will be dismissed. We want to do this to save our client and us time and money. Now, in order to file a successful motion for summary judgment or summary adjudication, you will need supporting material facts, and you'll need the following. Number one is a notice of motion by the moving party or asking for the summary judgment and or summary adjudication. Number two, a statement of undisputed material facts to support the motion. Number three, a memorandum that supports the motion. Number four, evidence that supports the motion. Number five, request for judicial notice that supports the motion. Number six, a separate statement in support of the motion, which will include a statement of undisputed material facts and must separately identify each cause of action, claim for damages, issue of duty, or affirmative defense that is subject to the motion. And seven, documentary evidence in support of the motion. Now our timeline. You'll need to file the motion for summary judgment or summary adjudication at least 60 days after the general appearance or proceedings and no less than 75 days prior to the hearing if the motion is served by mail. The motion is to be heard no more than 30 days before trial. The motion will need to be made as a declaration under oath and will be given to all parties and filed with the court. Templates are provided at the bottom of the page to serve as examples of what a motion for summary judgment or adjudication would look like. And again, as a reminder, the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you to consult with an attorney.